Can you hear me? Can you hear me?
Wait, let me check if it's my if it's their board. The air stuff. Yeah.
So you can hear me perfectly. Okay, so ladies and gentlemen, standing before you for the last time is Olayeni Dear Kolola News. When I mean for the last time, I don't mean ever. I just mean on this subject matter of terms of contract. At least for a while. Standing before you for the last time on terms of contract. Because I've thought this is the 10th class. Actually, there was a break in transmission in the 9th class. So we have 9th class A and 9th class B. Part one on, the part one of these terms of contract implied by court. So which means that we had about 11 different classes on terms of contract. If you go through my videos from 1, 2, 3, 4, 5, 6, and you don't pass this thing in exam, my spirit will appear and wipe you clean. I'm talking to one particular person and she knows herself. My spirit will appear and wipe, because I calm down to teach this to every single person for you to have the perfect understanding. So in our last class, we discussed implied terms by the courts, right? And then we looked at two tests, right? We looked at the officials bystander test. I told you that there were three cases to look at under officials bystander test. What are the three cases? We look at the Morox case, what Lord Bowen said. We look at Shello versus Southern Foundries. What's the name of that guy again? Can't remember. I can't remember his name, but the case is is it Shallow? I can't remember the case. Give your phone so I'll be able to put myself in order. So sorry, just give me a minute so that I can get myself together. So yes, McKinnon in the case of Shallow, yes, versus Southern Foundries. So we have three cases: the Moorcock case, the Shallow case, and the last one is the Nigerian case of Okotete versus Electricity. Let me look at it. Electricity Corporation of Nigeria. Yes. So look, you have those three cases to cite. That's my first class, right? And then you have at least two cases to cite for what's it called, the necessity and reasonable test. That's necessity versus reasonable. You have the case of what was that case, Greaves versus Bayham. Then you have the case of Liverpool City Council versus Ewen and all that. So if the issue is on bystander, you know what to go for. If the issue is on necessity, you know what to go for. And I would advise you, when you have an issue on necessity, or you have a problem question, what's problem? Or you have a problem question on necessity and all that, you write that on reasonability and necessity. I know that. So okay, so with that, we go to the class that we have for today. And yes, now today's class we'll just be looking at how many cases? 1, 2, 3, 4 cases. They're very little set of cases, just 4. Now while we are looking at these 4 cases, we want to look at it from the angle of those 2 tests that I had already given you in my first class. That's the officials bystander and what the necessity test. So we look at the first case of Western African Automobile versus Engineering Company Limited. Western African Automobile and Engineering Company Limited versus Saba Balogun. Now permit me that I'm using a phone. My system is dead, so just permit me to do that. So as I was saying, the court held that the Court of Appeal held that there was an implied term in a hire purchase contract for a lorry that the installment, you know what hire purchase is, right? Hire purchase is, give me the phone, I'll pay in installments, right? At the end of the installment, I have the option to get purchase the phone and all that. So that's hire purchase. Do you understand? So you pay instrumentally until you have the option to purchase at the end of the day. So now it was held that the Court of Appeal held that there was an implied term in an hire purchase contract for a lorry, that the installment were to be withheld as long as the lorry, due to frequent breakdown, was incapable of carrying goods, which was the main purpose of the hire. Now, they are saying that the other party who gets a lorry can withhold payment of the installments, because the lorry which he got on hire purchase, to which he's supposed to pay instrumentally, broke down or breaks down incessantly and all the time, right? So the court held that if it's breaking down, the essence of it breaking down is what? The essence of getting the lorry was to do business, that's transportation business, but this lorry is always breaking down, the transportation business cannot be achieved. Why then are you paying instrumentally? So there is a term to be implied by the court. It was not expressly stated between the parties that when it breaks down, do you understand? And I don't think it covers any of the, or at least the lawyers did not bring it from any of the either by statute or by trade of custom. So therefore they argued before the court that the court should imply the term. So we look at it from officials bystander, and we look at it from necessity. So let us look at which did the court look at it from. Now the court said, we do not think it unreasonable to imply that a seller of goods. Now I want you to note that he said unreasonable. We do not think that is unreasonable. Quote that. We do not think that it's unreasonable to imply that a seller of goods under hire purchase agreement could contemplate not being paid if the goods, that is, if they are supposed to perform certain functions, vehicle that's carrying goods in this case, that if the goods, for example, vehicle carrying goods in this case, are not performing such functions, if such inference can be drawn from the evidence and surrounding circumstance. So what he's saying, that it is not unreasonable to him that the person who is supposed to be paying instrumentally in relation to something that he got, if that thing does not function in accordance with the purpose of the contract, in accordance to the reason why he got it, it is not unreasonable to him that the installment should therefore be withheld. Now if you look at that, that does not fall under, it could be argued that doesn't fall under necessary term of the contract, like necessary test. It falls under the reasonable test. But if you are looking at it from necessary, you know that I told you that necessary, that is the only feasible. I told you to look at Lord Salmon's test. What is Lord Salmon's test? That if you take away that thing, that implied term, that the business will no longer be what? Will no longer be what is it called? Feasible, or it will now be, it will be fertile rather. It will be fertile, it will be absurd, or it will be there's this word that he used that I'm trying to remember. Let me get it so that I can just go straight to that word. He said, fertile, unefficacious, and absurd. Unefficacious rather. So fertile, unefficacious, and absurd. So according to what he's saying, that if you use the test, remove that term from the contract. That is, remove the term that he should withhold money if there are no installment. Now remove that term from the contract. He should withhold money if the lorry is not performing proper functions. Yes. So if the lorry is not performing proper functions, we told your money. If you remove the term from the contract, according to the test laid down by Lord Salmons in Liverpool City Council versus Ewan. Now, in that, if you remove that term, does that make the contract, that hire purchase contract, does it make it what is the word? Does it make it fertile or absurd or unefficacious? Does it make it that? The answer will be yes, because what is the other option for the hire purchase guy? Do you get? That's the only reasonable thing. If it keeps breaking down and there is no other way to go. Now, the reason why I needed to say this to you is because Professor Sage opined that by this decision, the court appears to have adopted Lord Denning's radical, just and reasonable test with greater vigor. Now, I need you to understand this when you are coming to your conclusion in exam. In as much as Professor Sage has opined that this particular test used in the case of West Africa Automobile and Engineering Company Limited versus Saba Balogun, Professor Sage is saying that this test is what is just and reasonable, following Lord Denning's test in Greaves and Bayham, and also at the Court of Appeal in Liverpool City Council versus Ewing. Professor Sage is saying that it is just a reasonable test, because don't forget that the words of the judge himself was that he deems it unreasonable. But I need you to understand that something can be of necessity and can be reasonable at the same time. So I want you to, can you help me pass my marker? Yeah, in as much as I don't think that you can see the board, but please just try to see what I'm trying to do. Now, there are two circles here, and those circles are overlapping. Now, this is reasonable, this is necessary, but there are some points where reasonable and necessary will overlap. In this case, reasonable and necessary overlaps. It is necessary for him to withhold money if he's not getting the benefit of the contract, as in what he intends to use the lorry for, if the lorry keeps breaking down. So there should be an implied term by the court that the lorry should not be breaking down repeatedly, or else he would withhold money. Do you understand? It is reasonable to do that. It is also necessary to do that. Do you understand? So where Lord Wilberforce in Liverpool would have a problem, even that of Liverpool as well, which I wanted to say but network was giving me wahala, is that it can be necessary and it can be reasonable. But the thing that Lord Wilberforce was saying is that do not use the reasonable test, because what is necessary is reasonable. If you look at it, all things that are necessary are reasonable, but not all things that are reasonable are necessary. That is why you don't use the necessary test. Are you listening to me? The reasonable test. Thank you very much. So all things that are necessary are reasonable, but not all things that are reasonable are necessary. That's why Lord Wilberforce said you cannot infer reasonability into the contract. You can infer necessity by implication. While inferring necessity, then reasonability comes in, because anything that is necessary is reasonable. Do you understand? But not everything that is reasonable is necessary. So in this case, why Professor Sage is submitting that this case seems to apply just and reasonable test, I'm saying no, it just appears to apply it, but in context is also applying that of necessity. Because if you look at it in operation, in practice, you would say that when lorry is breaking down, then it's just but necessity, because even the person, it is the lorry, it is from the produce of the lorry, that is the goods that he's delivering, that he's getting money to pay you instrumentally. So if instead of him to get money to pay you, all he's doing is using his money to what's it called, to repair the lorry, by implication there is no money to pay you. So by necessity, where do you want him to get the money? Do you get? If somebody is using money for lorry business to repair the lorry, where do you want him to get the money to pay you? By necessity, there is no money. So by reasonability as well, it will also imply that you should not pay. Do you understand? So moving on, what we're saying, we then go to our second case of Mazin Engineering Limited versus Tower Aluminium. Mazin Engineering Limited versus Tower Aluminium. In that case, the appellant placed an order for special aluminium roofing sheets from the respondent. So he said, I want to buy special aluminium roofing sheets from the other party. and the latter made it clear to the appellant that this particular type of sheets were not available in the country and would only be ordered from Belgium. The court held that there was an implied term that the obligations of the party would only be enforceable on the approval by central bank of the respondent's application for foreign exchange to effect the necessary order from abroad. Now, while they were talking, they did not put it as a term of a contract that it is upon approval, but they knew, because he told him that, we cannot get this particular roofing sheet that you want. We can only get it from Belgium. Do you understand? Now, now there is a term, according to the CBN's regulation, that if you want to get something from outside the country, you must apply to the CBN. So the CBN must approve. So the court would have to imply that as part of the terms of the contract, that for that contract to be able to continue, then if you look at that one, that was not official bystander, because they might not have contemplated it, but it is part of the term of the contract. Because if you are looking at it, is necessary for you to get the approval of the bank. I don't think they what is it called? I don't think they discussed it. Maybe the other guy just told him that, we'll get it from Belgium. But because they did not get it on time, then they sued them for repudiation of contract and all that. Then the court is telling them, you cannot sue him like that. Why? Because, there is a necessary term that implies that you cannot sue on this contract to repudiate it, except because this term is only operational when CBN approves. The contract is only operational when CBN approves. Do you understand his application? Do you get what I'm saying? So the court had to imply that it is necessary. That one is not reasonable. Let us leave reasonability. Let's not look at necessity. It is necessary that for him to get anything from Belgium, CBN must approve. That is a necessary thing. Do you understand? So, which means that term is a necessary implied term that the court has to bring into the contract. Do you understand? Now, is it also reasonable that the court brings it into the contract? Yes. Because, it's going to do hardship. When you're talking about reasonability, we'll look at whether or not it will do hardship, whether or not it is fair and just. It's going to do hardship. It's going to be unfair to the other party who has already applied to CBN to get the roofing sheet, but is waiting for CBN's approval. And now this other party now wants to repudiate the contract and all that because this party has not gotten it. Is it not going to be unfair? It's going to be unfair. It's not just, it's not reasonable. So, do you understand? So it is reasonable for the court to imply it. But like I said, in every necessary term, there is a reasonable sense in it. Do you understand? So, but it's not in every reasonable sense that there is a necessary sense in it. So do you get? For every reasonable, you don't need to have necessity, but every necessary you would have reasonable. So in this case, it is necessary for CBN to approve before so that has been implied into the contract as a necessary term, right? That's and then it could also be reasonable. So I hope you understand that. That's our second case for today. Let's go to our third case for today. And the limitation of the court's power to imply terms are also contained in the test prescribed in the cases. Thus, if the reaction of the official's bystander if the action of to the official's bystander's inquiry would have been uncertainty, disagreement, or a clear I don't know by any of the two parties to the contract, then the court cannot imply such a term. So this is what we are saying. That when we're using the official bystander test in a shallow and Southern Foundries, we said that if the official bystander says yes of course, after listening to the party, he says yes of course, they must have contemplated it, then what? Then you will pass through the official bystander test to say that it will be implied by the court. But according to the law as well, when the official bystander has certainty or has disagreement between him or within him, and where he will outrightly say, I do not know if these two parties are going to agree on the term. Then if the three instances, uncertainty, disagreement within him, or a clear I don't know, then that term cannot be implied into the contract. The only time the term will be implied into the contract to pass the officials bystander test is when, according to the case of Shello versus Southern Foundries, where the officials bystander says, of course, yes, of course. Do you understand? Now we then move to the third case, the case of Realgate versus Union. Realgate versus Union Manufacturing Company. Realgate is spelled R-E-I. Realgate, R-E-I-G-A-T-E. Realgate versus Union Manufacturing Company. Now, it was agreed between the plaintiffs and the defendant company that in consideration of £1,000 inter alia, and I told you in one of my classes that inter alia means another thing, amongst other things, rather. So, in consideration of £1,000 amongst other things paid by the plaintiff to the defendant, the latter would appoint the plaintiff sole representative for the sale of its goods in the United Kingdom, India, etc. for 7 years. So this is what we are saying. We are saying that we have plaintiff and defendant, and then the plaintiff said that, oh, for 1,000 naira you are going to appoint the plaintiff. The defendant is a company, so that is obviously Union Manufacturing Company. The plaintiff here is Realgate. So Realgate is telling Union Manufacturing Company, I'm giving you 1,000 naira, and this 1,000 naira is for you to appoint me as the sole representative of the sales of goods. So I'm going to be representing you when you are selling your goods in UK, India, and okay, just in UK, India, and other countries. I think for 7 years. And other countries for 7 years. Now, the defendant company became bankrupt, and its business was sold to another company. So the defendant company, that's the union, this thing, was then sold to another company who bought the company because the company was bankrupt. Now, the plaintiff sued the company for breach of contract. The defendant, in its defense, that's the company, in its defense, alleged the existence of an implied term in their contract to the effect that the agency relationship was to terminate should the contract cease to operate. Now, I want you to look at it from the officials bystander. Now, you know that there's a new company now. The old company got bankrupt, so it was bought in by the new company. So Realgate, who was the sole representative of the agents of the other company, now sued this company for breach of contract. And then this company is now saying that there should be an implied term that the moment that company got bankrupt, that the agency agreement ceased to operate at that point. Do you understand? So, as an officials bystander, do you think that it would have been contemplated by the parties? You know that there are two tests. Number one, whether both of the parties, officials bystander test, whether both of the parties would have contemplated it, that they had it in mind but did not express it. And number two, whether even if they had it in mind but did not express it, or they did not even have it in mind at all, whether if the question has been asked, their response would have been yes, both parties. So in this case, would the response have been yes if they had said that, where the company goes bankrupt, that the agency automatically terminates? Would the response have been yes at the time they were making the contract, for it to be well enough to be implied by the court into the contract? So I just want you to think that's the perspective where the court will come from when the court is answering the question. So now, the court rejected this argument. Why? The termination of the agency relationship would not have been obvious and unanimous decision of the parties in such a situation, if you look at it, because at that point when the parties were making their contract, there was nothing that could have made them envisage that, when the relationship, there are two things. When they ask the question, if the other contract goes bankrupt, the agreement will cease to exist. If it is brought to their attention, the second leg is that the both of them must say yes. It must be such that it could be implied from the way they've conducted themselves that at the point where they bring it to their attention, the both of them must say, yes, it should come to an end. Do you understand? That is what we are talking about for the officials bystander test. The first one is that the both of them had it in mind, but they did not express it. The second one is that whether or not they had it in mind, or they did not express it, or they did not have it in mind at all, if the question was raised, in this case, what is the question? That if the agency agreement, if the company goes bankrupt, the agency agreement will be terminated. So if that is the question, if they ask both parties, and at the point of making the contract, would both parties have said yes? That is the question, and the court said no, because it was not so obvious at that point that if the question would have been raised, the both party would have said yes, the agency agreement should be terminated. Do you understand? That's what the court held in that case. So the termination of the agency relationship would not have been obvious, and unanimous decision of the parties in a situation, and it would not have been obvious as well. Now, it then restated the rule. A term can only be implied if it is necessary in the business sense to give efficacy to the contract. I told you that when you are talking about the necessary test, then you are talking about the business efficacy and all that. But I don't know why the court is using the test in this instance. But let's continue. That is, if it is such a term that it can confidently be said, if at the time the contract was being negotiated, someone had said to the parties, what will happen in such a case? This is the judge talking. So if it is such a term that it can confidently be said, if at the time the contract was being negotiated, someone had said to the parties, what will happen in such a case? That is, in such a case where the company goes bankrupt, would it be that you want your agency agreement to be terminated? They would have replied, of course, so and so will happen. That the both parties unanimously would have made that decision. We did not trouble to say that it is too clear. It's part of what their response should be. That of course it is clear, if this should go bankrupt, that the company should go bankrupt, our agency should be terminated. Now, the court now applied it to this case. In this case, the parties would not have come to a consensus about what would happen if the company should collapse. They could have agreed to a refund of a proportion of the plaintiff's money rather than the implied term that the defendant company was alleging. Can you see? That's the implied term of cancellation of agreement. So you see, at that point, the officials bystander cannot say to a certainty that the both of them will agree that yes, so the company has gone bankrupt, or the company has collapsed, or the company has liquidated, and that's because of that it equates to the fact that the contractual relationship must therefore cease. Do you understand? It doesn't. The officials bystander cannot come to that conclusion. Like the court had also implied. He said, of course, they could have said that, okay, at any point, give me back 50% of the money, give me back 70% of the money. That could have also been something they would have acknowledged. Do you get? So because the officials bystander cannot say that, both parties will agree on this, then the court cannot imply it as the term into the contract. So you can say that the court did not follow the necessary rule. Do you understand? The court followed the what? The officials bystander rule. And I told you that I think is the officials bystander rule that is the officials bystander rule is the what? Is also known as the what? I won't say anything. Let me go to the next case. God. The officials bystander rule, I can't remember what I said. I was also known presumed intention. The officials bystander is the presumed intention, also known as the presumed intention rule, while the second one of what is it called? Necessary test is also known as the business efficacy rule. So yes, let's move on to our last case of Spring versus National Amalgamated Stevedores and Dockers Society. Spring versus National Amalgamated Stevedores and Dockers Society. I'm already getting very, very tired. How many minutes is it now?
30.
Getting very tired. So the defendant union was a member of an association of unions known as the Transport and General Workers Union. At a conference of all its component unions at a town called Bridgeton in 1939, it was agreed that a member union should not admit anyone quitting another member union without paying all dues and fulfilling all financial obligation in the latter union. The defendant union admitted Spring in ignorance of the fact that he was a member of another member union and that he had been in default of his financial obligations there. The defendant union, on discovering this fact, purported to expel Spring. He countered by bringing an action for breach of contract, claiming that the expulsion was ultra vires, and asked for an injunction to prevent it. The defendant argued that there was an implied term in their contract with Spring that they would comply with the Bridgeton agreement and take any appropriate steps to fulfill it. It was established that Spring knew nothing of the Bridgeton agreement, nor was he expressly included in the defendants union's rule. Now, before we go to the judgment of the court, let me explain this case, because I know that there has been a lot of English. So we have one person, Spring, and we have another person. Unions could be persons in law. That's why they are sued. They are called juristic persons. So National Amalgamated Stevedores and Dockers Society. Let's just say Stevedores and Dockers, or National Amalgamated. Let's just say Stevedores and Dockers Society. So we have this society. All the societies came together. All of them. All the Stevedores and Dockers in the society came together, and then they made an agreement. That agreement was made in Bridgeton, known as the Bridgeton Agreement. It was not written in their laws. It was just an agreement that they made. And then they said that any member in a member union, which is any of the bodies under the umbrella society, is Stevedores and Dockers. So let's say we are saying National Transport Workers of Nigeria, the national body. So we now start saying each of the states, or even in Lagos State, we now start saying each of the areas. So Surulere, NUTWR or something, National Union of Road Transport Workers. Yeah, so NURTW something. So if you are saying that of Surulere is different, that of Ejigbo different, that of Akoka different. Do you understand? So that's the same way this agency, the whole body, has different ones. They said if there's a member in any of these different ones and he wants to leave one union to go out to another union, that other union should not accept that member until he has paid all the dues in the former union. Do you understand? Until he has paid all the dues in the former union, he should not be accepted in the next union that is about to enter. Spring entered a union and they did not know that he was a member of a previous union. He did not know that he was, they did not know, that's the people in that union, did not know, God. They did not know that he was, sorry for that, So as I was saying, they did not know that he was a person in another union before, so they just admitted him. On finding out that he was in a previous union, what did they do? They then decided to expel him. And then he said, no, you cannot expel me. And then they brought him to court. They said there was an implied, the court should imply as a term that contract that they had, that Bridgerton contract, it should be an implied term of the court. Now, look at it from the officials bystander perspective. Is it that both parties contemplated it, especially when it was admitted in evidence that Spring did not know of the Bridgerton agreement? Do you understand? If Spring did not know of the Bridgerton agreement, then you cannot use the officials bystander rule. Why can't you use the officials bystander rule? Because it says that the both of them must have had it in mind but did not express it. Spring did not know that there was a Bridgerton rule. Now they want to expel Spring, and Spring is coming to court and saying that you cannot expel me because it's ultra virus. That means you cannot do it per the agreement and all that. That's the constitution of the union. And they are saying that it is an implied term into their contract. They were coming under breach of contract. So he was coming under the agreement, under the law guiding the association. That per the law guiding the association, it cannot be removed. They are saying, no, we are not coming under the law guiding the association. We are coming under, that's counter arguments. So they say they are coming under breach of contract. So under breach of contract, they said that he had broken an implied term. What is that implied term which the court ought to imply into the agreement? They said he has broken an implied term. What is the implied term? That he was supposed to have paid all the dues in the former association before this one. Okay, no problem. Let us assume that is to be a term to be implied by the court. Per what test will we bring it into the contract? If you go per the officials bystander test that the both of them must have had it in mind. The first leg, both of them must have had it in mind but not have expressed it. Did Spring have it in mind? No, Spring did not even know that there was anything known as the Bridgerton's agreement. So that means that this first leg will fail. Let's look at the second leg. That if both parties, if their mind has been averted to that particular question of the Bridgerton agreement, that both parties would have said, yes, of course, we intend to carry on with the contract like that. If it is, that there is this rule in this former case that we just read, that if the officials bystander will come up with three things: uncertainty, disagreement, or a clear I don't know, then the court cannot infer it. The court cannot infer whether or not Spring would have agreed to that term being implied into the contract. Do you understand? He did not even know that the term exists. But let us say that he knew. There is no guarantee for the officials bystander to come to that conclusion that Spring would definitely have said yes. Spring could also have said no. Do you understand? He could also have said no. So we do not know. Therefore, it fails the officials bystander test. So if we then go to the second one of the necessary test, what will work in this case is anything wrong? What will work in this case is the necessary is the reasonable test and not the necessary test. Why? Because it is not necessary for the Bridgerton agreement to be honored, for that contract to continue, to be efficacious, for the contract not to be absurd, for the contract not to be fertile. You don't need that particular term to be in the contract. Do you understand? You know that what Lord Salmon said is that let us remove the contract from the agreement. Would the agreement still have the efficacy of business? Yes. That before you leave a union, you should pay the dues of that union before you enter this union. Let us say we remove that from this contract. Does it stop him from being a member here? Does it stop him from carrying on his duties as a member here? Do you understand? It doesn't stop him. So does it take away the business efficacy of this contract, the necessary business efficacy of this contract? It doesn't. However, you see where I'm telling you that it intertwines. It is reasonable for you to bring it into the agreement. Why? So that when members are leaving one union to go to another union, they should have paid. That is a reasonable thing to do. They should have paid their dues and duties here. Do you understand? Before they go to another union. It is reasonable to imply it, but it is not necessary to imply it for that contract to stand. Can you see the difference? For anything that is necessary, there is an implied reasonability, but it's not in anything that is reasonable that there is an implied necessity. Do you understand? So in this case, it is not necessary for you to put that term into the contract for you to have its business efficacy of Steve Doe's being under a union. Do you understand? Let me use it for something that you can understand. So let us say that there is this NUWT or something like that, the National Road Transport Workers in Nigeria, in Lagos. And then they said, oh, if you are from Surulere, Amuwo, Odofin, Island, anywhere in Nigeria, anywhere in Nigeria, in Lagos, so that if you are going to leave one, and let's say it is car driving, if you are going to leave one area, you don't want to be driving car in that area, give them notice and pay all your dues before you go to another place. So this person left Festac, that's one area, and came to Surulere and was doing transport business. He registered there, and now they want to push him out, and he's now looking that, why are you pushing me out? Let us apply the necessary test. If you imply that, oh, you must have paid your dues there and all that into the contract, does it take away the fact that that man can drive? No. Does it take away the fact that he can drive in that place? No. Does it stop him from doing whatever he wants to do there? No. Does it take away the business efficacy in the contract? No. Is it necessary to adopt that contract, to imply it, to adopt that term into the contract? That's to imply the term in the contract. Is it necessary? Is it such that when you remove the term, the business is now, the contract is now absurd, the contract is now futile? No. The contract can still be carried on regardless of whether or not it's there. It doesn't mean anything. So it is on that ground that the court will imply the necessary test. But in this case, even you and I would know that the necessary test will fail. If we follow law Denning, if I'm the lawyer on the other side and I can see that, oh, it's not possible for me to wiggle my way around this, I'll try to resurrect the bones of Lord Denning's argument in Liverpool City Council's case. Do you understand? So that I will use the reasonable, not try to reason with the judge's sense of justice, sense of fairness, and then try to bring it in. My lord, look at it in the context of the business, in terms of reasonability. My lord, don't you think that when you tell them to pay dues here, and then they are going from that place to another, that those people through which they are supposed to pay their dues, and it's going to be to their own detriment if this is not included in every contract? Imagine the dues is owing is 100,000 naira or 1 million naira in a place, and now you are telling him to leave that place and continue business in another place around the same association. My lord, don't you think, do you understand? Don't you think what I'm telling the Lord, my lord, is that let us look at it from the reasonable point of view. But when we are looking at it from the necessary point of view, it's not necessary. Can you see that? So those are the 4 cases that we'll be discussing, that we have discussed on today's class. You know, the 4 cases you need to know. So when you're entering the exam hall and you are told business efficacy, or that is the necessary test, or the what is it called, or the officials bystander, when you are told in the exam, I keep saying it, if it's an essay question where they told you write everything, write all these cases and the rules very fast as I have said it. But if they say write just the official bystander, mention the necessary test by the way in 1 sentence or 2, and then when you are done with that, continue with officials bystander and give adequate response to it. If it's a problem question, if they say officials bystander, you don't need to mention necessity, or look at officials bystander and answer it on the merits. The only time you can mention necessity is if it falls short of the officials bystander rule. Then let them know that there is another test to apply if the court would imply it into the contract. That is the reasonability test, and then quickly apply it and conclude whether or not it's going to be applied. Simple. The moment you do that, contract isn't hard, especially terms of contract, and we are done. We have done everything on that terms of contract from the beginning to the end. We've learned every single thing in 10 to 11 classes that we've had so far. We've learned every single thing that you need to learn on that terms of contract. So I'm glad that I got to this point, actually, and I'm very tired and exhausted. I just hope that I wish you the very best in your exam. If this is the only class that you need, I wish you the very best in your exam or in your test or whatever it is that you want to use it for. Maybe you're making a research for your work or any court of law document or whatever it is, or a book. I wish you the very best. I hope that it's going to help you as much as you need it to. So we'll be moving to another topic, exclusion clauses. I will see if I can upload more videos on exclusion clauses as soon as I can. Thank you very much.